Welcome to the Nuts and Bolts of Real Estate Podcast. My name is Joe Bauer, and I'm here with my co-host Julie Clark. Julie, how you doing today?
I'm good. I am surrounded by windows here in my home office, and I can't find a spot that isn't glaring sun in my face right now, which is super awesome. So, yeah, you guys get to enjoy me moving around a little bit today, maybe. But I'd rather be where you are because you are in one of my favorite places on the planet.
Yeah, I'm in Bend, and I'm surrounded by wind right now. So if you see me moving around, it's because I'm cold and shivering.
Oh, man. And Kaitlyn, we got our friend Kaitlyn Jackson from Dimension Law Group back with us today. We're going to go round two, guys, on updating you all on the tenant landlord laws. We're going to touch upon Tacoma and some of the other cities as well today towards the end of our show. So stay tuned. This is going to be jam-packed information. This is part two. If you didn't watch part one of our podcast and our show with Kaitlyn, where we initially covered this topic as well, Joe's going to drop it below, and you guys can go watch that one first and then watch this one second, or however you want to roll. Massive amounts of info coming at you today. So let's kick it off. Welcome, Kaitlyn.
Hey, thanks for having me today. I'm looking forward to providing hopefully useful information for your listeners on what is happening right now in landlord tenant law, not just nationally, but statewide and locally. Like I said, or like you were mentioning earlier, we've got some changes to Seattle, Tacoma, Burien, pretty much all the little cities surrounding Seattle. You're going to find that there's updates and changes.
Well, let's jump into it. I'm going to literally just turn the mic over to you today because we have so much to cover. So let's do it.
Great. So hopefully I don't end up repeating too much information from the last session that we had, but if I did, more information for your listeners to kind of settle in their knowledge of what's going on. So one of the biggest things that happened pretty recently was the CDC Eviction Moratorium was overturned by SCOTUS, which I think anybody who understood constitutional rights and property rights saw coming a long time ago. But it was good to kind of have that issue resolved. In addition, we have the CARES Act provisions that specifically affected some of the landlord tenant laws. Some of them sunsetted, but some of them will remain in effect because they did not provide an end date to certain protections. So if your property or a property of your client or friend is subject to these CARES Act protections, you may need to make sure that you check a few boxes before you move forward with any terminations or with certain notices sent out to occupants of the property. An example there is that for terminating tenancies, the federal law in certain circumstances requires 30 days notice, regardless of what the state law allows. And many states do allow, for example, month-to-month tenancies to be terminated by, like a 20-day notice. Well, if your property is protected by the CARES Act, it may require an extended notice period. So those are just things to look out for at the federal level.
How would you know if your property is covered?
Well, there's a definition in the CARES Act, but then on top of that, there's a link. I think if you just Google link, like, is my property subject to the CARES Act? You can look at what is the definition of what is protected. Because if you own fewer than 4 homes, I think there's some exemptions from these protections. But mainly the issue is, do you have a mortgage on the property that is federally backed? And if it's federally backed and it fits into some other minor definitions, you probably are subject to the CARES Act. But thankfully, there are some websites, and I don't have them off the top of my head, but I would just Google it, that you can actually look at the definition, check your mortgage status, and pretty much discern whether or not you are subject to the CARES Act. My piece of advice is really just make sure you give 30 days notice if you can. But that's essentially where that's headed. I have a feeling, though, that even those provisions at some point will sunset, because we will hit a point where these protections are no longer needed and they may fall away. I don't see the benefit of having federal law long-standing for the, foreseeable forever future on terminating tenancies being, necessary. So moving on from the CARES Act, we know that the last governor's proclamation, which was the eviction moratorium in the state of Washington, the last iteration of that was 20-19.6. That expired June 30th of 2021. However, the issue is that the governor then implemented a new form of an eviction moratorium in Proclamation 21-09, which was then extended to 21-09.1 and now has been modified into 21-09.2. So essentially what those are different versions of the eviction moratorium and different timelines for ending. So right now, the current iteration is 21-09.2, which is an eviction moratorium statewide that is set to expire October 31st. But what it really is sort of described as is a bridge moratorium. Its intention is to bridge the gap between creating these eviction resolution pilot programs in each county, give them time to get set up. So what had happened with the state legislature in April and May was they created these programs in state law that said every county basically needs to have these eviction resolution pilot programs up and running. And that has not happened in every county yet. And so the governor's office with these iterations is trying to give the counties time to actually get their programs operational. And so right now, as it stands, there's, 12 more days before things can move forward, quote unquote, normally, or at least in compliance with the rules or the laws that changed pursuant to legislative act in April and May, without any further hindrance or additional requirements from the government or from the governor's office. As of October 31st. I am taking wagers right now whether or not this particular iteration gets extended. I think we're 12 days out. I think we saw that City of Seattle, and I'll touch on this a little bit later, extended their eviction moratorium through January 15th of 2022. And then on top of that, Seattle also has their winter eviction moratorium, which is also in place until March of 2022. So I am thinking, I'm not necessarily a betting person, but I'm thinking that this iteration may be extended as well.
So let me just recap. At the moment, the statewide moratorium runs through October 31st, and we have by the time this is out, actually, it might be 12. I don't know how quick Joel will push this, but maybe 2 days, 2 weeks. 2 weeks. So we might maybe give us an update, confirm with us back, maybe Kaitlyn, if you can, whether they extended it or not. We'll probably all be able to read the news, but statewide, right now, as we're doing this on October 19th, is October 31st, which you're anticipating, taking bets that it'll get extended. But the City of Seattle, for example, and we'll go to other cities later, already has all their overlays in place through June of 2022. It's actually March of 2022 for Seattle.
Yeah, because they have two different moratoriums that are stacked on top of each other. Both this emergency eviction moratorium that's COVID related, right?
Right.
And then on top of that, they have an already in place annual eviction moratorium during the winter that takes place between, I think it's December 1st. It's either November or December 1st every year and expires March 1st of the following year. Like you cannot evict someone.
What was the June thing you said though? Didn't you say there was a June thing? I thought maybe I misspoke.
Maybe I misspoke. I know that in June 30th, 2021 was the expiration of the last governor's eviction moratorium before the new sort of versions of these moratoriums, the 21-09s started. as we'll call them bridge proclamations, where they're not necessarily moratoriums, they're a bridge. That is just political jargon for I didn't want to violate the specific requirements that the legislature put in place, because the legislature in 5160, which was the actual House and Senate bill that was passed, specifically said to the governor's office, the governor's eviction moratoriums shall not continue past June 30th of 2021. So the governor just basically called this a bridge and basically just played those games and did it anyway. That's basically what happened. The biggest difference, I think, that is important for listeners, especially me as an attorney getting phone calls, emails, and questions about what protections actually exist right now, is what is the difference between the current protections and the old protections. The current eviction moratorium that's in place really only covers non-payment of rent cases. Like if you're talking about for protecting tenants from eviction processes for non-payment. Any other type of action you need to take as an owner or a landlord, if it's not related to non-payment of rent, there aren't very many protections set forth in the new versions of the proclamations, the bridge versions. The previous proclamations were much more expansive. So the intention here is to really, the government or the governor's office to really just focus on protecting tenants for non-payment due to COVID, situations. The unfortunate thing that's the reality for many, I think, listeners, landlords, property owners, is really that these issues are often intermingled. You usually don't have a perfect tenant that is also $20,000 behind on rent. Usually there's behavioral issues, there's lease violations alongside with it, and these proclamations and these protections make it very difficult to navigate. Well, can I move forward or can I not move forward because I have this list of other issues? And the current proclamation that's in place, 21-09.2, basically says if any action is based in whole or in part on non-payment of rent, then you have to go through this, process. And I'll get into that process here in a little bit. So if there's an argument that by the tenant that the issue is partially based on rent, whether you say it or not, that can cause further delays if you need to get access to your property for some reason. So, but that's the biggest difference. So I think this would be a good moment to sort of go through what does the current bridge proclamation require in terms of non-payment of rent cases? Because if you're a property owner, property manager, getting paid is probably the most important aspect of your job or of your, capitalizing on your asset. So essentially what has to happen is that between now, if you're dealing with rent that has accrued between February 29th of 2020 and July 31st of 2021, so that's roughly a year and 5 months, any unpaid rent that came into existence during that time period, landlords are prohibited from serving any notice that requires the tenant to vacate until both the county that the property is located in has a rental assistance program and eviction resolution pilot program that are operational. The newest version of the Bridge Proclamation thankfully defined operational, but it has to be a program located in the county in which the rental property is located in, and they are receiving or able to receive applications for rental assistance from eligible renters and landlords, and is currently dispersing or able to disperse funds. So that's like part one of what has to be in existence for you to even serve your notice. You can't serve your notice unless you have an operational program in that county. And then the second part of that is a tenant has to be provided with and has since July 1st, 2021, rejected or failed to respond within 14 days of receipt of a notice and an opportunity to participate in that operational rental assistance program. So basically, first thing you have to establish is, does my county have an operational eviction resolution pilot program? And if so, then I need to send a notice to that tenant, giving them the opportunity to participate in that program. If the tenant does not, respond or decide to participate within 14 days, then you may have guidance from that county's local standing order in the Superior Court about what your next steps have to take. So essentially, the biggest issue that practitioners like myself are finding is these little tiny definitions within what is considered operational. So if you listened carefully, one of the pieces of the puzzle is that eviction resolution pilot program in the county receiving or able to receive applications, and are they currently dispersing funds? And many of these programs have an online platform that will say, okay, submit your application, and then they can basically just respond or choose not to respond or say, we are not dispersing funds right now. And so if you have a program that looks like it exists, like if you're looking up to see, do we have one in Snohomish County, for example, you're researching, is there ERPP up and running? You have to somehow confirm that they're actively dispersing funds before you'd even have the right to serve the notice. And that's a really, that process is near impossible to really
So they can turn it on and off maybe one day they're...
Exactly.
So what I would do is if I was a landlord and I checked and it said yes, I would screenshot it, or I would, of that, and you just grab that proof that on that day that I gave my notice, dated the same as the date of my screen, that I had the right to give that notice. Is that fair?
Yeah. Yes and no. I mean, yes, if it's accepting applications, because remember, you have to have both elements, that it's accepting applications and it's dispersing. Now, whether they're dispersing funds is totally unknowable to you until you've actually submitted an application and they've accepted it. So what we're finding is that you could go through the entire process. You send your 14-day notice for the tenant to participate. The tenant even participates and submits their own application for assistance. And then it just sits there for an unknown period of time. I have cases where applications have been submitted back in May of this year, and there's no status update. So even though it looks like the program is operational, there is no timeline for them to respond. There is no requirement to force them to respond, because really they can just say they're not operational because they are not currently dispersing funds right now. So it's one of those issues that has to be navigated sort of carefully. And many...
I've lost track. What are we even trying to accomplish right now? Are we trying to accomplish what is it? Why we're doing this? I've lost track of.
Yeah. So we're trying to get rent and rental assistance. So the whole point of all these legislative barriers to moving forward with a notice is because the governor's office has said we need a bridge between these programs becoming operational and landlords being able to move forward and getting their funds or their properties back, right? And so this process is what is put up to sort of bridge the gap in time. They're trying to protect it. However, to me, it feels like a self-fulfilling prophecy. If there's no reason for these programs to get moving because there's no penalty or no danger to the tenant that things will move forward without them, that's, then the governor's office gets to turn around and say, oh, well, we still have all this money we need to disperse and it hasn't been dispersed yet. We need another bridge. So it's just kind of a fascinating cycle. But yeah, the whole point of this is to help get tenants and landlords access to these rental assistance funds that have been provided by the federal government and also the state government for basically reinstating tenancies that have fallen, behind within the last 2 years-ish, right? This is where we're at now. So that's the navigation structure for non-payment of rent cases while this current proclamation is in place. many people are intimidated by this process, rightfully so, especially landlords, and are electing to try to just wait until these proclamations expire before they do anything. The other issue that is likely to come up if you are a landlord that does decide to participate is that the mitigation fund, so some of the funds that have been set aside for landlords, is limited in how much you can recover. So the Washington State Landlord Mitigation Program limits landlords for up to $15,000. And if you accept those funds, many of the documents will say you cannot pursue the tenant directly for anything more than the $15,000 that you've accepted from the government. Now, I think I touched on this last time, but if you have a tenant whose rent is, $2,000 a month, they've been in non-payment status since March of 2020, you're now well beyond $15,000 in what you're owed. So by accepting any funds from the government, you're risking having to walk away from tens of thousands of dollars of what you're actually owed. So that's another, and the longer these moratoriums go in place, the more dollars actually get stacked against the tenant for liability on that.
You know what I wanted to, was thinking the other day, one of my shower thoughts, there's an insurance policy called business interruption insurance, right?
Yeah, many times, yes.
And isn't this considered an interruption of your business in some ways, that you'd be able to make an insurance claim if you had that on your policy?
I wish I could answer that question, but that's going to depend on your policy, and that's going to depend on your
I am going to, Joe, note to self, we're going to ask Elaine Eugenio to come on the podcast.
But I can tell you this from experience with other clients, that definition of what is an interruption is incredibly narrow. So I don't think that there's actually as many policy holders out there who would benefit from that type of a claim as I would hope.
Well, maybe, yeah, I'm curious because that sparked my interest. But what are you having clients that are like, what in the hell? I can't pay my debt on my property because I'm not getting paid. Are you having anybody in that situation?
Oh, I'm having many clients' homes foreclosed on. The rental properties are being foreclosed on because they can't pay the mortgage on it. And there's worse cases. I won't say that I have a client like this, but I know of others whose clients are elderly and they've relied on rent to pay their medical bills, who are, not getting their medication to stay alive because they can't afford it because the tenants are not paying rent, and they're not forced in any way to apply for any programs or rental assistance programs because of these moratoriums. Yeah, that's a reality. And I will say there aren't really going to be very many studies done that, like right now, that will show the damage of how many single family homes and rentals are actually leaving the market in Washington State, mainly because you can't really even terminate a tenancy. Take Seattle, for example. You can't terminate a tenancy with 90 days notice or any notice at all to sell the property, full stop, right now. So you may end up or many of these properties are being either sold off or will be sold off once the moratoriums or protections are lifted. And so you're going to have a shrinking of the market, especially single family homes. And you're going to have rent increases everywhere, significant ones.
Right. It's like a total backwards thing here. This is crazy. This is just nuts.
Well, it's really, and I don't mean to, I'm not a conspiracy theorist by any means, but what I predict happening is the market shrinks, rents raise significantly to deal with increased risk, increased cost, spreading out losses that occurred during the moratorium. And then that gives the government of Washington the reason to turn around and say, see, this is why we need rent control and legislate that. But it's kind of, to me, the theory that you created the weather and now you're complaining about the rain. So that's what I foresee, being very, very likely, or at least something that is heavily debated.
We're going to steal that. You created the weather. Now you're complaining about the rain. Joe, bookmark that one right there.
Right. Okay. So basically where we are at is that you need to understand the process for if you are an owner of a property or a landlord, going through these mandatory mediation processes and whether or not you can move forward. And certain counties are moving forward. Some counties are moving forward and then turning that little off switch on where it's like, oh, we were accepting applications, now we're not. So you have to deal with that. But at the end of the day, I foresee that relatively soon, landlords should have the right to basically force tenants to these eviction resolution processes. And if you give what we call the offer of reasonable repayment plan, which is a requirement, which is defined by statute, and they don't allow it, then you can move forward. So what the legislature did in 5160 back in May of this year, May of this year, they defined what was a reasonable repayment plan. And it is essentially, you have to offer to the tenant, like let's say they have a debt of $20,000 that has accrued since February 29 of 2020, and their monthly rent is $1,500 a month. You have to offer them to pay that $20,000 off to you interest-free with no more than 1/3 of one month's rent payable at any given time. And the first one can't be due for 30 days. So hypothetically speaking, if I had a tenant that was 20 grand behind and their monthly payment was $1,500, I'd have to say, dear tenant, my reasonable repayment plan offer to you is $500 a month, which is 1/3 of rent, beginning. And if today is October 19th, the first payment wouldn't be due until November 20th. But I mean, personally, I just started on the first of any month, and they have an unlimited amount of time to pay that back. It is interest free. It cannot be, subject to any additional requirements like compliance with lease terms or really anything. That's just basically all you can offer them. And if they accept, they have 14 days to accept it. If they do not accept it, that's when you can move forward with your eviction resolution pilot program notices that say, hey, we need to go to mediation and you need to participate. If
what
they
if
do
they
not
accept it and then they just don't pay?
Okay, so that's happens a lot. So that's the portion where you can either submit the pilot program documents, like the offer to mediate this issue with them. Or you can go to the landlord mitigation funds that are distributed by the Washington State Department of Commerce. So there's a website, Washington State Department of Commerce, landlord mitigation funds, and there's these different buckets of money that you may qualify for as a landlord. Like I mentioned before, that's a question for you as a landlord that's a little tricky, because if you dip into those funds and you say, hey, my tenant agreed to this payment plan, it was reasonable under the statute, here's a copy of my lease agreement with this person to show that this is a legitimate, request, please pay me. They may pay you, but they're going to say, but you can't pursue this tenant for any more money than what we give you. So if you're owed 20 grand, you're going to walk away from 5 of that, assuming you get the maximum amount.
How are you ever going to get the difference anyway?
That's a good question.
Where are you going to get the difference of the money? The tenant doesn't have it. So
I think that's an assumption. I mean, yes, totally. You're right. I think that's sort of, I call it, don't try to squeeze, the common saying, don't try to squeeze blood from a turnip, right? And if the tenant is a turnip, you might as well just take the money you can get and try to continue with the relationship. The problem with that is, one, you're still required to keep the tenant.
Right.
So you're going to end up in a situation where, what are you going to do? Go back and ask for more money in 3 months when they're all, still continuing not to pay? That's another problem. And then one of the other issues is, some tenants, and this is, more common than I would like to admit because I've seen it in my practice, but they do have jobs. They do have the ability to pay, and they've just sort of become very complacent with not having to and not having any consequences. So Hopefully not very many people are experiencing that. And I am aware that because I'm an attorney that practices this area, I probably see the worst case scenario every day. Kind of like what I assume nurses in the
any of this, though, can affect the tenant's credit, or is there some rule there that
That's a really good question. So it's the proclamation speaks to in what is an enforceable debt, and also the House bills that were passed also put prohibitions on reporting tenants' credit. So until you've actually gone through the formal processes and gotten a judgment, you can't really do anything to report negatively on a tenant's credit.
How about if somebody wants to rent from me and I say, great, part of my application process is I need to call your previous landlord?
Nope, you cannot do that either. That is part of the how the Senate and House Bill 5160 or 1236 that said if there's potential landlords cannot ask about any unpaid rent that accrued between February 29th of 2020 and the expiration of the protected dates, which I think the protected dates go through December 31st of this year, and they may be extended. So you can either tell a future landlord if you have a tenant moving out about unpaid rent that accrued during that time period, and you're as the prospective landlord, you cannot ask about it.
I can call up and I say, how was your experience with Johnny? My experience was
my experience with, I would say my experience with Johnny is that they were a tenant between this date and this date.
Right.
That's pretty much all I'm saying.
Right? Yeah, exactly. This is absolutely nutty and crazy. So the whole point right now we were talking about is the path to try and evict somebody. If you want to try and evict somebody,
for non-payment of rent, right?
For non-payment of rent, you have to offer up this reasonable payment plan based on the terms you told us. Mm-hmm. And then if they don't accept that, you can move forward.
You can move forward if your county has an operational eviction resolution pilot program
that you can apply to.
Right. And the definition of operational we discussed is a little bit
right. Different. Right. But if there is no, that's it. So there is no, that's it. Those are your choices. If that doesn't exist, you can't move forward.
You can't do anything. Right. If you don't have an operational rental assistance program, you can't even serve the notice at all.
But once you serve the notice, then you can get the funds, and then you're stuck with that tenant and getting some of that money maybe until it basically starts over. Then right? Then
you're talking about the reasonable repayment plan. So the reasonable repayment plan offer is different than the notice. So first, you always have to start with the reasonable repayment plan, because if they accept it, you really should just be focused on getting that money through the reasonable repayment program, gotcha. through the reasonable payment arrangement. Then if there's a default of that, or if they don't agree to it, then you have to offer them that opportunity to participate in the mediation program. They have 14 days also to respond to that. So they've kind of used 14 days consistently as like the response period. So you're going to hear 14 days a lot. 14 days to respond to the offer of the reasonable repayment program, then 14 days to respond to the opportunity to participate in the eviction mediation program process. And then if they do participate in the eviction resolution program, that's a whole other bag of rocks that you have to deal with. And that's assuming, once again, that you can't even offer them to participate in that eviction resolution pilot program unless it's operational. You can't start that even conversation if you don't have an operational program within the county the property is located in. So you have a lot of boxes to check. So moving through, let's say hypothetically, you have a program that's operational. And if you look at Pierce County, they've got a pretty much, almost operational program going, if not fully. And then Snohomish County, I think there was an article recently that showed that they have been giving out the most money of almost any program. They're good to go. So let's say hypothetically, you've got the 14-day notice or the 14-day offer of the reasonable repayment plan. The tenant responded, but declined it. Was just like, you know what? I can't afford this. and then you moved forward and sent them the 14-day notice or offer to participate in the mediation program, but they signed up. They said, yeah, let's do it. That process, county by county, is really also another confusing, process, because each program runs differently on different timelines even. So, for example, I've heard that King County, if you do voluntarily participate in their program as a tenant, they only have one mediation a week that they have as a schedule on their schedule. And I don't know if they've updated that since I've, talked to my contact there who did it. But that means that if you have, hundreds of people applying, thousands of people applying, when will that ever happen? When will you ever get your mediation done? So that's another problem, is there's also a struggle with getting the mediation process completed. The process requires that before you can move forward and go to the court, right, and say, hey, court, now it's time for you to resolve this rent issue, you have to have a certification of compliance from the mediation program. And that's another issue, is there some of them, even if you're participating, even if you show up to mediation, even if you do everything right, and it doesn't resolve itself because maybe the tenant's just like, no, I don't want to pay more than $3 a month, and I don't care what you tell me, I'm not going to do it. Some of the mediation programs are just not issuing the certifications, and nobody knows when they will, or they're not giving you a timeline. And so then again, you're stuck in this no man's land. What
if my tenant has lived there for 2 years, 24 months, let's say, and their lease expires during this process, or their lease is expiring during all this process, and I'm in Seattle or whatever? I can't give them
Well, you just said the magic word there. You're in Seattle.
Okay. So is there any way I'm not going to evict them. Can I give them is there any way that I can, since they've been there a long time, they're not a new tenant, they've been on the lease, I can't give them a notice to vacate at all?
You can do nothing if you're in Seattle.
What if I'm in federal? No, that's a bad one.
Nope. You're just going to keep stepping it. Let's just say not a regular runs, a city or a local county that has no additional protections other than the state protections. The question is, it depends. So if their lease expires, and you did everything right according to the new just cause ordinances. So let's say, hypothetically speaking, they had a 2-year lease. You sent and it was the initial lease term. You sent the 60-day notice ahead of the expiration that the lease term would be deemed expired for no cause. And you checked all those boxes. You could move forward, hypothetically speaking, with an eviction or an unlawful detainer if they refuse to leave at the end of their lease. The problem that I foresee with that is if you've already started an action or a mediation process regarding non-payment of rent and it's not going well, the secret language in the current bridge proclamation says, for dealing with any action based in whole or in part on rent arrears accrued between February 29th, 2020 and July 31st, 2021. So there's an argument there by the tenant and the tenant's attorneys that the reason you're really moving forward is based in some part on non-payment of rent.
But if I never applied to that program, I never did anything, and their lease was expiring.
Right. Yeah. So I have seen those cases move forward successfully in many instances.
In regards to giving them a notice to vacate.
Right. So at that point, if you already did your 60-day notice of non-renewal and they are still there after the expiration, you don't need to give any further notice. You just serve and file an unlawful detainer because they are in holdover status. And so those ones are not, those types of cases are not protected by the current bridge proclamation. You may have local issues that you need to deal with, but by the bridge, no, this does not stop you from doing that.
What if somebody was there for, now in a regular city, they were just there on their first 1-year term? Is there a 2-year lease? We're getting into the Seattle stuff, right? If it's just their first 1-year lease, and their 1-year lease is expiring in 90 days from now, right?
We're talking just regular state law, not any local ordinances.
Regular state law.
You can send your 60-day notice of non-renewal and let it expire, but you have to make sure it says this the magic.
And then after it expires, then you give them the 20-day notice to vacate or 30-day notice to vacate.
No, you give them no further notices.
No further notice. They're just in holdover, and you can have the sheriff come and get them out or whatever.
Well, you got to go to court first.
Go to court, right?
Yeah. I have to deal with that question a lot because people think like, oh, I can just bring the sheriff out there. I'm like,
hey guys, it's Julie here with a quick break from the show to discuss an opportunity some of you may have interest in, which is to work more closely with me. On almost a daily basis, I get calls from investors and brokers, both new and experienced, asking me for guidance or advice. I love helping you guys out, and it keeps me on my toes too. So with that said, I wanted to let you know that I have a private broker coaching community called the VIP Education Community. And the best part is that it's 100% free. That's right, it's free to join. So whether you're a traditional broker or a broker investor, my VIP education community offers personalized one-on-one coaching from not just me, but also from my experienced broker friends with expertise in all disciplines of real estate and real estate investing. We'll teach and share our modern marketing strategies, our tech and lead generation resources, plus teach you how to identify or offer up opportunities for yourself or for your clients using techniques such as seller financing, lease options, land entitlement deals, BRRRR investing, flipping, multifamily or commercial coaching, whatever you like. We've got it all covered for you. The future of real estate is changing fast, and to stay in the game, it's time to learn about all the options you can offer your buyer and seller clients, as well as, if you want, learn how to use those skills to grow your own real estate portfolio. If you'd like more details about joining my VIP education community, reach out to me at julie@seattleinvestorsclub.com or text me at 206-910-2985 or just send me a Facebook message. My new favorite phrase is community equals confidence. So let's navigate the future of real estate together. Now, back to the show.
What are normal places? I mean, this is city by city.
I think Snohomish County is still pretty state. They pretty much just let the state run the landlord tenant acts. But I expect that the current political race that's in place in Snohomish County at the city council level may change that. If, you have to look at what the platform is that you're voting for. And if there's a housing platform, then you need to be concerned that things will change there. Yeah.
So that same question, and I'm in Seattle. Okay. And then that's when that's the whole just cause thing that kicks in, right?
Well, just cause is statewide now.
Just cause is statewide. So if I'm in Seattle and I have a lease that's expiring in 90 or 120 days, and I've never applied for anything to get any money, so I'm not going to cross that line. And this comes down to first or second lease term type stuff, right? In Seattle, which we covered in the first podcast. Doesn't it?
Yeah. First or second lease term actually is that's the state law.
Okay.
Basically, it just has to, you have the right to terminate or let a lease expire for no reason or cause statewide if the lease is for a certain amount of time and it's in the initial lease term, or it never went month to month and it doesn't have month to month terms in it. There's a whole bullet point list that you have to hit. That's not just Seattle, that is statewide now. So whatever was sort of normal in Seattle is now also statewide.
But if somebody's month to month, right? And let's say they've lived there for 3 years, 5 years, and they're month to month because the building owner that's what they did. They're old school, mom and pop. They've been there long term. Doesn't that just mean that, or I'm asking that you can't give just your notice is a longer period of time? Or you just can't give them the notice at all? They have to be on the lease in order to give them the notice. So you got to put them on a lease in order to be even to give them a notice, right?
Well, okay. There's two ordinances that affect the city of Seattle right now, which is they have their own eviction moratorium that does not allow you to terminate even for cause. So whether that's month to month or term is irrelevant in Seattle right now. The only reason you can terminate anyone's tenancy in the city of Seattle is if they are a significant and immediate health and safety risk to others. And that is a whole, process. If we are not if we're talking outside of Seattle's, COVID related eviction moratorium and their winter eviction moratorium, and we're just talking like outside of COVID regular, if you're in the city of Seattle and you have a month-to-month tenancy with anyone, you have to give a reason that the city of Seattle has pre-approved in their ordinance for why you are terminating the tenancy, and you have to give the timeline associated with that reason. So hypothetically speaking, if you outside of COVID, that would be a 90-day notice of intent to sell the property or a 90-day notice of intent to personally occupy the property as a primary residence. Those are some of the causal reasons to terminate a month-to-month tenancy. If they are a term tenancy, state law protects term tenancies in the sense where if it doesn't fit this like narrow definition, then you have to have a reason why you're not renewing or why you're not, basically why you're terminating that term as well.
Gotcha.
If that makes any sense. And it doesn't make a whole lot of sense because there's so many layers you have to peel back first before you can figure out what you have the right to do. And Seattle's obviously the most extensive right now. I mean, I think the most recent, and we'll get into this as I go down the process here, but Seattle has passed a mandatory offer of renewal. So the state does not require you to, mandatorily, you must offer this tenancy to this tenant again, but City of Seattle does. So you basically are very limited in what you can even let a tenancy terminate for.
If somebody's a holdover tenant, let's say somebody moved out that had somebody living with them and that person, like a roommate, stayed in there, you have to offer that roommate a lease. That's one of the things, right? You have to offer it to them, even though they weren't the one on the original lease. The original leaseholder left. Somebody else stayed behind, the stay behind tenant. Are you allowed to screen that person at all?
So in Seattle, it depends on whether or not that person, the remaining occupant, is defined as an immediate family member. Now, the immediate family member definition in the code is very, very broad. Basically, anybody you've ever had a relationship with is somebody that spouses, extended family, I think grandma, grandpa. I mean, it's very extensive or broad. If they're an immediate family member, I don't think you're allowed to screen them. And that's just off the top of my head.
If they're not.
What are you going to screen them for anyway in Seattle anymore? You can't do a criminal background check. You also can't discriminate on source of income. I mean, you're pretty much you can't also even look at, previous evictions for the last, almost 2 years. So it's almost kind of irrelevant at this point. And I predict that Seattle will also, you also can't require, a social security number or something like that. So I think that credit score is also coming very soon.
Jeez Louise.
Yeah. But so if it's an immediate family member, I don't think you can screen them. If they are not an immediate family member, I do think you can screen them. Statewide, if it's kind of similar. So if a tenant basically leaves without informing the landlord or informing the landlord, and they've allowed someone to live with them for at least 6 months, there is you basically have to offer that person an opportunity to become part of the lease before you can terminate them as well. Though they do have to apply, and they do have to meet the same requirements that the previous tenant basically had to meet to get the lease. So
okay.
A little bit different. Yeah.
Man.
Yeah. It's a minefield statewide. I'm secretly sort of hoping that one day we just decide, okay, let's just have the state run these laws, like having all the local city ordinances and also the you have county ordinances on top of that is just becoming so cumbersome. But I guess it's a business assurance for me. So.
Yeah, really.
Yeah, but I wouldn't like my job to be this hard. Okay, so moving forward, I think we've sort of got a good general overview of the process if you are trying to pursue a non-payment of rent case in the state of Washington. You know that you're going to have to follow this eviction resolution pilot program process. You know you're going to have to offer a reasonable repayment plan. Once again, you want to make sure that if you're moving forward, you want to look into whether or not your county has an operational rental assistance program before you do anything other than offer the reasonable repayment plan. There's nothing stopping you from offering that payment plan now, regardless of whether the program is operational. And sometimes I would argue that it at least can get a productive conversation going between landlord and tenant. Sometimes. I wish I saw it more, but sometimes it does happen. So the other big changes that have happened since our last conversation is that the just cause ordinance, state law, just cause termination provisions from 1236 and the eviction resolution programs of 5160 have now been codified into landlord tenant law. So if you're somebody that is comfortable reviewing RCW 5918, which is the statewide Residential Landlord Tenant Act, that's now you can find this information in the actual act itself. So the pilot programs, the eviction resolution pilot programs are found in 5918-630, whereas the statewide just cause termination limitations are found generally in 5918-650. There are some pieces of those acts that were spread out in other places, but those are the general places where you can find that information. So if you're somebody that's like, gosh, can I terminate a tenancy for X reason? And what is the timeline? You'd want to go to, and you know that your county doesn't, or your state doesn't have, or sorry, your city doesn't have any additional protections. That's where you'd go to look for that information. Okay. So moving on to, also one big point about new laws being implemented is now we have statewide right to counsel for indigent tenants. So I don't know if I talked about this last time, but now tenants who make 200% or less of the federal poverty line qualify for a free lawyer. And I'm sorry, I hate that word, free lawyer, a taxpayer funded attorney under the state's new right to counsel program. And they should, seek immediate legal assistance if they receive, a notice to terminate. 200% of the federal poverty line right now is $25,760 for one person, or $53,000 for a family of four. So that's just sort of to give you context. So what will happen is if you go through this eviction resolution pilot program, or if you serve a notice to terminate for any reason, if the tenant qualifies, they will, have access to basically a public eviction defender. And that person's job is to basically try to find reasons why you can't move forward. So what we are finding is that that's another barrier to moving a case forward, because if you have a right to counsel, but your county hasn't actually created a program or trained attorneys to be the public defenders, if you will, and I'm just using that loosely because it's more understandable, cases are getting delayed significantly. I know of a case where the public defender was assigned to the case, and then just kept coming to court over and over again saying he wasn't trained, so he wasn't competent to actually defend this person, and to continue delaying the case, which I thought was just beyond fascinating to me, that you could be assigned a case by the county and they can assign somebody who self-identifies as incompetent. That's just okay. So that's another little hiccup to deal with. So moving forward into Seattle, I think we talked a little bit about it. Seattle's a hot mess of legislation when it comes to landlord tenant rights. As many people probably already heard, they extended their eviction moratorium through January 15th of 2022, and they have the winter eviction moratorium. So you already have that. So we know that the only reason you can evict somebody right now is because they're a significant and immediate health and safety risk. But they also passed 180-day rent increase notice, and that goes into effect November 9th of this year. So that means that if you are planning on raising rent, you have to give 180 days notice in order to put that into effect if your property is in the city of Seattle. It includes all increases to periodic or monthly housing costs, except for changes to subsidies. So if you have a parking fee that needs to increase, or if you have garbage fees that need to increase, if it's anything that would be considered periodic and it's going to increase, and I'm sorry, that's correct. Sorry, I needed to go back a second. You need to give 120 days or 180 days notice before those can increase. All rent increases for month-to-month tenancies issued on or after November 9th must provide the 180 days notice. So if you have increases that you're going to send notices out about, get them out before November 9th, or you're going to be.
Is there a layer on top of how much that rent increase can be? What if it's more than 10%? Do you know what I mean? In Seattle?
So there's additional protections so I don't think that there's a minimum or a maximum. If you're going to increase it any amount, it's got to be 180 days. If you're going to increase it 1%, it's got to be 180 days. At least that's my understanding of it. And as this is new, once again, I mean, it's brand new, and I could learn new things and have to retrain.
Isn't that maybe one way landlords could, and it has to be reasonable, can't be crazy, but isn't that one way landlords will be able to get tenants moving along?
Force a tenant out?
Get tenants moving along.
So you're going to get into situations where they call it economic eviction, where you just increase the rent so much that it makes it impossible for the tenant to want to remain there. Once again, you have to remember every indigent tenant has a right to counsel now. They're going to get a taxpayer funded attorney. And if something is unreasonable, you're going to get into economic eviction world, and you could end up having to pay a lot of money to that tenant to vacate or potentially even deal with damages. So, but
if they're not Indigent, there's a lot of people that are having problems with the not Indigent crowd of tenants, right? I hear you.
Yeah,
right.
There are a lot of them. I mean, I think we're going to get into more about like the 10% maximum minimum, issues in Seattle with the mandatory relocation assistance program that was created. So I think that's where it's more, the 10% issue is more appropriately discussed. But the reality here is that if you're going to increase any costs in Seattle and it's month to month, you need to give 180 days notice of that. I think that the practical problem that is brought up by this is the fact that when you're a property owner and you have property taxes increase, your timelines for, spreading out those increases and dealing with them in your contracts becomes pretty complicated if you have to give that much advance notice. So, I think that something from SDCI basically said to me, but obviously this was not in a formal setting where they were like, we'll be held to this type of situation. But just general guidance was that if you're going to increase the rent for the next year, if you're going to renew that lease term or offer a lease renewal, you just have to basically do all this, 180 days in advance, or after November 9th, you can always send the offer of first refusal, which is, I think you have to send it between 60 and 90 days in advance of the expiration, but you might not have the increased rent costs go into place until at least 180 days in advance. So you may end up in a situation where you're drafting your lease agreements as a landlord in a way that's much more similar in commercial leases, where they have a rent schedule for each year built into the lease. So it might be built in monthly. So you might say, hey, it's 75 days out before your lease expires. Here's your offer of renewal. Lease terms or rent terms are going to stay the same for the first 2 months, because now you're getting into your timelines here, or 3 months. After the first 3 months, starting this month, they're going to increase to X amount. So there's different ways you can sort of make sure that this is built in. But that's what I see people doing after November 9th, is basically building out a schedule in these offers. Or, every 6 months, just sending 180-day notice, the rent's going to increase.
Right. But if I was buying a building, because we're a lot of investors listening, and it was all month-to-month tenants, because that's what mom and pops do these days, and I was going to buy that building, and of course, I'm buying it because it's an opportunity, because the rents are under market or whatever, but they're not indigent. Let's just say they're not in that crowd. They're a regular crowd. I would be able to buy that building, and I would be able to give all those tenants, if they were all month to month, a 180-day rent increase.
Yeah.
So for investors who want to budget to buy properties, right? When they're doing their due diligence to underwrite what their holding costs are in this new world, they would need to understand that they're going to get the rent that's there for at least 180 days there, no matter what. And then however long it takes, if somebody decides not to take that rent increase, to go to court and pursue their termination of their tenancy because they didn't accept the new lease, right?
Right.
How long does that take?
The court process itself?
Yeah. Mm-hmm.
Probably 2 to 3 months.
So if I was buying a building, that's what I'm saying. So now I'm at 5 months for a rent increase. I'll say 6, because I'm going to get in there and I got to kind of wait a month to give my notices, or I'm in a weird time of the month. So there's 6 months out the gate, plus another 3 months at least, and then throw a buffer on. So that's 10 months that I'm going to buy a month-to-month tenanted building, and I'm going to live as is for 10 months with those rents. I'm just, as an investor, that's what I'm thinking. Right.
And I think you have to also remember, like, if the issue that you're dealing with as an investor is non-payment of rent, right? Or,
what if I just leave that all behind? I'm not going to deal with the non-payment of rent. I'm going to budget. I'm going to buy it. They're not paying, whatever. That's part of my budget to buy the building, is I know they're not paying. Cool. I'm going to buy it anyways. Right. And I'm just going to build into my budget, buy the building, that I'm only going to get X amount of rent, my own cash flow schedule for those first 10 months. Some of that might mean that I'm not getting paid rent, but I don't think I want to tie up and pursue this previous rent issue because I'm buying the building. That's the problem of the last guy.
Right. I guess maybe what I would be thinking about is, when you buy these buildings and the tenants are month to month, and you send a rent increase, like you're talking about 180-day rent increase, mm-hmm. and that person does not pay, right? At that point, what are you going to do?
At that point, when they sign the lease and they agree to it?
Maybe they don't.
Maybe they don't what?
Maybe the tenants don't sign the lease, right?
Yeah.
And they don't agree to pay the rent increase, and they don't vacate. The biggest issue that I see right now, maybe this is something that I've just been dealing with in the last 2 years, and hopefully by the time we are talking about this in 6 months from now, is not an issue. But if the tenant then decides, I'm not accepting these new lease terms, I'm not accepting the rent increase, and I'm just not going to pay, you have no remedy at this point in Seattle.
You're just in limbo. You're in purgatory.
Correct.
You're in purgatory.
Right. And if you're thinking about, okay, well, then the mandatory mediation process needs to play out. Once again, King County, even though it's the biggest county and has probably the most money, is not operational. They call themselves not operational. It's just politics at this point. But
so it would be better for me as the buyer of this building then to then work it through my offer with the seller as part of my conditions of closing. I would like you to put everybody at their current rate on a 6-month lease. Can they offer a 6-month or does it have to be 12?
No, they can offer a 6-month lease. I'm not playing devil's advocate. I'm just curious, what is the objective of getting them on a lease? Because you have a right of first refusal. There used to be a benefit, right? Of if I have somebody on a lease term, I know that at the end of that term, they have to vacate, right? That was the benefit of a lease term. Mm-hmm. That benefit doesn't exist anymore in the city of Seattle because you have to offer them a renewal, for one, unless you have specific requirements, unless you have just cause. And any of these tenancies you're talking about, they all were month to month after September 30th of this year, which means no matter what types of terms you get them to sign up to, you have to have just cause to terminate even a term lease. That's the new statewide law. So any tenant that was month to month as of September 30th of 2021, if you didn't get them to sign a lease before that point, because that tenant was month to month at some point in the past, you now have to have just cause to even terminate a term lease. The end date on that lease, regardless of whether it's 6 months, a year, doesn't really matter anymore.
Right.
And that provision that's in the state law is particularly confusing, but we haven't even had a chance to litigate it yet. So we don't even know how far that's going to stretch. But that's an issue. So I think if I'm an investor and I'm buying month to month, if I'm buying a building with month to month tenants, the best thing that I can do is get estoppel documents from each of those tenants that ensures I know what terms they believe they are operating under. Because I can't tell you how many times I've dealt with investors who say, this is a copy of the lease from 5 years ago, and its rent has been raised X amount of times or whatever. But then once they buy the property, the tenant says, oh, well, actually, the previous landlord reduced my rent or did this or said that, right? And then you're ending up in a situation where you don't really know what assets or liabilities you just purchased. So it's basically just like commercial. Get an estoppel document signed by the tenants where the basic outlined terms are in a one signed document by the tenant so that you know what you're buying. That's my advice for an investor. Know what you're buying.
Mm-hmm. But if let's say okay, keep going. I'm going to go down a rabbit hole.
Yeah, that's okay. Yeah, stew on it later. So we touched on the 180-day rent increases that go into effect in Seattle on November 9th. Then on top of that, we already talked about a little bit the right of first refusal. So just to make sure that everybody understands what that means is that the right of first refusal in Seattle requires that a lease renewal be issued in a window between 60 and 90 days prior to the end of the lease term. And if you lay that over the top of the 180-day notice, Bill, it seems like your pathway forward as an owner in Seattle is to separate the rent increase notice from the renewal notice, issue them within their respective time periods, 180 days for the rent increase, the lease renewal notice in the 60 to 90 days, or issue the renewal notice 60 to 90 day window with the delayed rent increase. So we sort of talked about that a little bit. Lease renewals in the city of Seattle, you have to offer what is defined, they say reasonable lease terms. However, the code has now added a little provision that says, if the offer of a reasonable renewal is rejected by the tenant, it is presumptively an unreasonable offer. So now if you're going to move forward, you have to prove to the court in the outset of your complaint, if the tenant doesn't relocate, voluntarily, you have to prove that your terms were reasonable. What that looks like, I don't know until we litigate.
So your property taxes went up and you whatever.
Sure. I mean, when you get into the lawsuit land, you're talking the tenant can subpoena all your other leases that you have for all of your other tenants or lease renewal offers and make sure that every offer was exactly the same, right? And that's, so you want to make sure that you're very careful about what your renewal terms look like. And are you being uniform across the board? If you have a reason such as my property taxes went up, well, then everybody better be getting the exact same distribution of rent increases. So if you have other reasons that you're increasing one tenant more than another, you better have some documentation supporting why that's reasonable.
So again, you offer reasonable rent increase on time within the zone in the right notices, and they say, I don't accept. Now what?
Well, hopefully they leave on their own, right? Because that's the point, is they don't want to pay the increased rent amount or whatever it is. Well, hopefully they leave. If they don't leave, for one thing, you don't want to accept rent after the termination date. Because so let's say one of the lease terms was, I'm raising your rent from $1,500 a month to $1,800 a month. And that, may sound like a lot of money in one raise, but given that rent hasn't increased in 2 years and property taxes have skyrocketed, it's not that bad. The tenant, if they tender payment for $1,500 a month come the first of the month after the termination should have happened and you accept it, now you're in trouble because you don't, basically you've just created a new lease for that.
What if I don't? Then what?
If you don't accept it and they don't leave, that's a unlawful detainer action, meaning no further notice required at that point. You just file and serve an unlawful detainer and move forward with the eviction process through the court system. Once again, this is all assuming that you can at this point, which right now in Seattle, you cannot, and not until mid-January. Can you do that? So.
Right.
Rent increases are particularly tricky because if the person's income has stagnated, and they can argue that maybe their income has stagnated because of COVID, you also have the additional Seattle protection of, I think it's like 6 months after the expiration of their eviction moratorium, which is in place through January. Then they have an automatic defense to any eviction based on COVID for 6 more months. So even if you've offered the reasonable lease renewal, it has increased rent. If they can say, well, I can't pay the increased rent because because of COVID, because my income is stagnated, whatever that looks like, technically they have an affirmative defense that could defeat that as well for a long time. So there's another hiccup in that. So mandatory, the other big law that was passed, and you and I have talked about it a little bit already, is the mandatory relocation assistance for low income tenants after rent is increased by 10% or more. So this bill was passed a couple weeks ago, and it basically, if there's a low income tenant and you're the landlord and you increase the rent by 10% or more, they can come back to you after they vacate and require you to pay them relocation assistance of up to 3 months worth of rent. That starts in July of 2022. So if your rent is $2,000 a month, you're going to pay them $6,000 after the fact if they come back and apply for it. So
if you what? That's if you did what?
If you increase rent 10% or more in a year, I think that's right. I think it's limited to a year, obviously. And the tenant vacates because they can't afford it, right? And they're considered low income. They can come back and require you pay them relocation assistance of 3 months or more. 3 months worth of rent. So I think the example provided by SDCI was, if a landlord raising the rent on an apartment from $1,600 a month to $1,760, that landlord would have to pay $4,800 in relocation assistance. The city collects the money and gives it to the tenant.
Right. So stay under 10%.
Right. And I do think that the tenants have to make, so they have to be low income, and that's defined as they make 80% of the area's median income, which is about $65,000 for a single person or less to qualify for that additional relocation assistance. And I think it's worth, remembering that there's already a relocation assistance requirement for low income tenants. If you're the owner of a property in Seattle and you intend to substantially rehabilitate the property, that requires, a 90-day notice provision and some specific steps you have to follow by getting a permit from the city to move forward, et cetera. And I think that that type of situation is limited to something like $4,200 that is divided between the owner of the property and the city. And that's provided to these tenants in order to relocate. It is not known right now whether those things stack on top of each other in certain circumstances.
I'm that we're getting close to 11 here, so we should probably, but we should talk about Tacoma for 1 second too. I just want to.
Sure. Okay, so moving forward from Seattle and the relocation assistance, the Tacoma updates are that they codified the statewide just cause ordinances in 1236 into their local landlord tenant or ordinances. And what that, from a practical standpoint, means is that they just have more strength in their enforcement rights of the statewide laws. And they also made some additional changes or adaptations to the just cause, statewide just cause ordinances. For example, shared housing. So generally speaking, if you're an owner of a property in the city of Tacoma, let's say it's a single family property and you share that property with a tenant, you can give a 20-day notice as long as it's not a term lease to terminate that, because the state wanted to protect that relationship between, hey, this is your home too as the owner, and you should be able to choose who you live with. But in Tacoma, if you're sharing that housing with I think it's more than 4 other individuals, you do not have the right to terminate any of those tenancies with 20 days notice, and you have to fall under some other just cause to terminate. That was intended to sort of like protect boarders and boarding houses, et cetera, that are, run by the owners of the properties who live there. There is a business license issue that came up in one of the meetings I had with them that I need to find more guidance on, but people should just be aware that I think they may have expanded their business license requirements to not only just the landlords of the properties, but also the owners of the properties. So just sort of put a pin in that, and I'm going to send you guys an update when I get it. But what I understood them to be saying in this meeting I had was that if you're the owner, and hypothetically speaking, if I own a single family property that is a rental property in Tacoma, and I also have a professional landlord who runs it, a property manager, then the property manager needs to have the Tacoma business license. But now they're saying the owner has to have the business license and the property manager / landlord has to have the business license. If that's the case, I see issues with that, because now the state's basically getting 2 business licenses out of the same business, essentially. So, but that's something to put a pin in for later. They also increased their fines for non-compliance with any of their landlord-tenant laws, notice requirements, et cetera. So if you violate it, I think the general rule is any violation that they find is $500 a day for the first 10 days. And if it's not corrected within those 10 days, it jumps to $1,000 a day.
What the hell?
Yeah. There are some proposals that they are going to.
Is that just for Tacoma?
Yeah.
What the Seattle doesn't have that type of,
I don't remember off the top of my head what Seattle's is, and it's changed a lot. So, but I do think Tacoma's is particularly aggressive. The quote unquote good news is that, they use it as a negotiation tactic. So if they find that you violated something and it's been 30 days, you've got this fine for something like $20,000 that they can assess against you. They usually use that to just force you to compliance and waive most of it. That's what I've experienced and heard from other practitioners in this area as well. But that's also a problem in the sense it's like, just issue the fine, make it a reasonable fine. But I think that these fines that we're discussing or penalties are pretty excessive, and they may be challenged from a constitutional standpoint as excessive. I wouldn't be surprised, because that's pretty excessive. The proposals that they have coming up are a late fee cap. So capping what landlords can actually charge for late fees for non-payment or late payments, and then increasing the notice of proposed sale requirements. So if you're going to sell the property, right now, state law says 90 days, right? But I think Tacoma is going to probably or it's at least talked about right now that they're going to propose an extended timeline for that beyond 90 days. So that's Tacoma. Just before we sign off here, Burien and Kenmore also extended their local eviction moratoriums. Burien just matched Seattle, so theirs is stretched to January 15th, 2022. However, Burien is a little bit more, I won't say lax, I will say forgiving, that if you are going to sell the property or personally occupy it, you are allowed to send the 90-day notices in Burien and do that, which Seattle does not allow landlords to do at this time. So that's the lay of the land. It's dense. It's horrifying. Every day is an adventure in landlord, tenant, attorney world.
If you wanted to sell your property or move into your property in Seattle, did you just say you cannot? Isn't that you cannot do that?
No, in Seattle, the only reason you can terminate someone's tenancy is because they are a significant and immediate health and safety risk.
Okay.
And even statewide, I think it's worth remembering that just cause for terminating a tenancy statewide now, you are allowed to give 90 days notice of intent to sell only for single family properties. If you have a multiplex, a duplex, a triplex, a fourplex, an apartment building, you cannot use that just cause to terminate a tenancy.
Yeah. Got it.
You got it. I need to get it.
I don't know. I feel more confused. It's totally insane. This is so stupid. Anybody who has a vacant property, why would they put a tenant in there? Why don't you just Airbnb it?
Well, that's another, I'm sure, a whole other podcast for you guys, is what ordinances are coming into place for Airbnbs, because it's my understanding that those are being cracked down on as well.
Yeah. Who's running the show on that? Who's paying attention in your shop to that?
I barely keep my head afloat, and I would argue maybe sometimes I don't on the landlord tenant stuff that's changing. So I pretty much ignore the short-term rental stuff unless a specific question comes my way, and just research it ad hoc.
I have a client that wants to move to Florida for 8 months and then sell their house. And it's not in Seattle, but it's in Kitsap County. And we said, don't put a tenant in there if you want to sell your house. Whatever you do, just Airbnb it out or something like that to earn your income during that 8 months, because you might not be able to get that tenant out very easily later, right?
Yeah. Depends. But in Kitsap counties, I look at the politics of the counties and the cities as well to sort of gauge what the likelihood of additional protections for tenants being brought. Kitsap County is probably unlikely to pass any additional protections than what state. So if it's a single family property, they have the right to terminate with 90 days notice. Sometimes Airbnbs make more money. So whatever is going to make
who knows what's going to happen in the 8 months that are
right. But that could be true for short-term tenancies and long-term tenancies. For example, I do think Gig Harbor put a pretty restrictive cap on short-term tenancy, like Airbnb properties.
I heard that.
I think that went into place just a couple weeks ago, or was just.
I heard like Leavenworth or somewhere like that, or Chelan. Also.
Chelan's been in place for a while now, because they were bombarded in 2018 and 2019. They did. I kind of go by the theory, or kind of hear the saying, like, this is why we can't have nice things.
Right.
Mainly because if you just have every single property in a rural area bought up by investors, and there's nowhere for locals to live or afford to live, right, you're going to create a scenario where they're going to have to legislate. So
right. Yeah.
This is why we can't have nice things.
Oh my God. Well, we're going to have you come back again, because we're going to pull a plug on this today because we went long. And unless you have one last thing you want to drop, I think we'll call it.
I don't have anything else other than, I know it's going to take you guys 2 weeks. And so the current eviction proclamation 21-09.2 may have expired. I'd be more than happy to jump on and just do a verbal update if that's possible.
Yeah.
A few days after the beginning of November.
Okay.
And as you guys know, I'm not going to be in the office after, November 20th or so. So
that's right.
You might want to take advantage of that.
Right. You guys didn't realize that there's actually 4 of us on this podcast today.
Right. That's correct.
Right.
Mm-hmm.
Yeah. You guys can read between the lines on that one. We won't out you there. Well, awesome stuff. Joe, how you doing? You warm enough?
Woo, it's cold out here, guys.
Sorry. We could go on forever, right?
It's cold in landlord tenant world, too.
Yeah. I don't know. Which one's colder? Is it colder in Bend or colder in Seattle? My God. It's crazy stuff, you guys. Just stupid. It's crazy stupid. But all right, Joe, give us the details. Kaitlyn Jackson, everybody, Dimension Law Group in Tukwila. That's where you guys are at, right?
Correct.
Mm-hmm. And you can contact, she has an intake form, which I have, or you can reach out to her if you want that intake form. You can hit me up at julie@seattleinvestorsclub.com, or you can track down Kaitlyn on your own. What's the best way that you would like people, if they are trying to track you down, to do that?
Email. Then I just forward it to my legal secretary to set up a call.
What is your email?
Kaitlyn@dimensionlaw.com. And that's KAITLYN @dimensionlaw.com.
There we go.
Thanks so much.
Thanks for joining us again. Joe, what are the details of today's podcast?
Yeah, if you'd like to get to any links that have been mentioned in the podcast, head over to seattleinvestorsclub.com/152. Or if you're watching this on YouTube, just go down to the notes section below.
And shout out to Certain Lending, who's the sponsor of Seattle Investors Club. They are our local hard money lender. They actually, I think they're up to 40 something states that they lend in. They also have a 30-year loan product that you guys all want to know about. Certain Lending, check them out, certainlending.com. And if you want to join us, everybody's welcome to join us for free every Thursday from 11:30 to 12:30 on Zoom. We have a virtual meetup where we talk about stuff like this and more, everything. It's an open discussion. And you can go to meetup.com, look for Seattle Investors Club, and grab that link for the meeting access. It does not change. So you can plug it into your calendar and join us every week when you can. That's all I got today. Thanks, everybody. Over and out. Till next time.
Thanks for listening to the Seattle Investors Club podcast. If you have questions that you'd like to have answered on the show, shoot us an email at info@seattleinvestorsclub.com. Now go out, take that action, and build that real estate business. Thanks for listening.